ఒకసారి రికార్డింగ్ పాజ్ చేశాను. అవును, యూట్యూబ్కి వెళ్ళిపోతుంది. అయితే స్టార్ట్ కొట్టేసి వీళ్ళు ఇంకా ఎవరైనా రావాలా? అంతేనా? క్లోజ్ చేసి ఓకేమా, షల్ వి స్టార్ట్? ఇంకా ఎవరైనా రావాలా? అంతేనా? రైట్. సో ఆల్ ఆఫ్ ఎ సడన్ క్లాస్ పెద్దదైపోయేసరికి మీరు తక్కువగా కనిపిస్తున్నారు. ఓకే, రైట్. So what we have discussed in earlier session, we have completed the discussion relating to classification of directors, and somewhere around 10 plus types of directors we have learned in the previous session. Executive director, non-executive director, managing director, whole-time director, nominee director, independent director, small shareholders director, women director, alternative director, additional director, like kind of lot of, with respect to lot of directors, we completed the discussion. Okay, so this is maybe not yours. Okay, right. So today we are going to learn qualifications and disqualifications of a director under Companies Act 2013. Qualifications are pretty much easy. Why? Because there are no specific qualification attributable for the position called director except independent director. For independent director only, Companies Act is specifically mentioning or specifically imposing few conditions. When it comes to other positions, other directors, no specific educational qualification, no specific age-wise criteria, nothing has been mentioned. And with respect to age, there is a restriction for position called managing director, and it is also somewhat very insignificant restriction. Why? Because we have already completed our discussion relating to MD, right? MD is going to have what kind of powers over the company? Substantial powers or insignificant powers? Managing director is entrusted with substantial powers of the company. That is why, if you are considering a person's profile for the position called MD, managing director, and the person's age is above 70, there is no hard and fast rule, or there is no prohibition, or there is no restriction that you can't appoint a person aged above 70. But if you are considering a profile aged above 70, SR is required. Which is required, ma? Special resolution is required. Nothing other than that. No restriction. You can appoint. Happily you can appoint. But all you need is to pass special resolution in the members meeting. That is general meeting. This is only age-wise restriction. That is only for the position of MD, not relating to any other directors and all. Okay. So qualifications are pretty much easy. We'll read the qualifications later. First of all, let's discuss disqualifications of directors under Companies Act 2013. Disqualifications, very important. Lot of practical questions has been framed on these disqualifications. Either practical case-based scenarios or straight away theory questions they will ask from disqualifications of directors. And the section, you have to remember these kind of sections. Why? Because these sections are so significant and important. And the section is 164. 164. This 164 can be broadly classified into three scenarios: 164 subsection 1, 164 subsection 2, and 164 subsection 3. 164 subsection 1, 2, 3. Sir, what are these sections pertaining to, or what these sections are communicating. 164.1 personal disqualifications. Personal disqualifications of directors. That means if director did that much activity, for that activity regarding the director is disqualified to act as a director. And so 164.1 talks about personal disqualification. If you did this activity, you are disqualified. If you did that activity, you are disqualified. Kind of situations will be discussed in 164.1. Whereas 164.2 company level disqualifications. Which disqualifications, ma? Company level disqualifications. That means according to 164 subsection 2, disqualifications will be attracted to directors due to the default committed by the company, not due to default committed by the individual directors. That means 164.2 talks about company level disqualifications. So if company did these kind of activities, all the directors existed in the company are disqualified according to 164 subsection 2, company level disqualifications. And last but not least, 164.3 talks about those disqualifications. 164.3 talks about those disqualifications specifically added in the AOA of the company. That means 164.3 is giving powers to the company to add certain disqualifications, in AOA, Articles of Association. So we'll talk about 164.1, 2, 3 in a slow and steady way. First of all, let's talk about 164.1. Tell me what 164.1 is saying us. Disqualifications of director on personal scenario or personal agenda. So, sir, what kind of disqualifications will be attracted to directors according to 164.1? Simple. If director is unsound mind. If director is, first one what ma? If director is unsound mind person. If director is a unsound mind person, is qualified or disqualified? Disqualified to act as a director of a company. That is first one. Second one, you very well know about this point, insolvency. If director makes an application to the court saying, requesting court that please adjudicate me as an insolvent, and his application is pending before the court, he is disqualified, or court specifically decided that this person is an insolvent. In these two scenarios, that means disqualification is attracting to directors due to the insolvency applications. In case number 1, the person made an application before the court requesting the court that please adjudicate me as an insolvent. Court did not take any sort of decisions with respect to his insolvency. The application is pending before the court. Even though the application is still pending before the court, you are still disqualified. That is scenario number 1. Scenario number 2, you made an application to the court and court accepted the application and court judged you as an insolvent. Court give a declaration, court order has been came, you are an insolvent. Court decided that you are an insolvent. In this case also, you are disqualified to act as a director. Are you following? Two scenarios we have completed. First one, unsound mind. Second one, insolvency. Insolvency, either court expressed the judgment or you made an application to the court and requesting the court authorities that please adjudicate me as an insolvent. In either cases, whatever the case may be, in both the cases, you are disqualified to act as a director. This is second one. This is second one. And third one, any court or tribunal, any court or tribunal specifically disqualified you to act as a director of a company. Any court or a tribunal, tribunal means usually in Companies Act, NCLT, National Company Law Tribunal. So any court or tribunal specifically disqualified you to continue as a director or to act as a director, then disqualification attracts to you due to this provision. So first one what? Insolvency, yeah? Unsoundment. No need to follow the specific order, whatever your order you can follow. First one is unsound mind. Second one is insolvency. Third one is any court or tribunal specifically disqualified you to act as a director, then also you are not supposed to act as a director in any company. Or public company, a private company, a OPC, doesn't matter. You are disqualified to act as a director, that's it. And next one, imprisonment. Next one is what, ma? Imprisonment. So imprisonment. So when it comes to imprisonment, your disqualification is directly relating to your period of imprisonment. Say for example, your period of imprisonment is very minute. On a drunken drive case, you are charged with you are punished with 10 days imprisonment or 12 days imprisonment, 1 month, 2 months, 3 months, like that. It doesn't matter. No specific disqualification. Say for example, if your period of imprisonment is less than 6 months, if your period of imprisonment is less than 6 months, no specific disqualification occurs to you. You can continue as a director in existing company, or on a fresh note also, you can be appointed as a director of any company. Why? Because your period of imprisonment is less than 6 months. If your period of imprisonment is more than 6 months but up to 7 years, then after your period of imprisonment has been closed or your sentence is expired, from the day, it means the release date, from the release date, not from the imprisonment starting date, from the release date, 5 years you are disqualified to act as a director in any company. How many years, ma? 5 years. Sir, my period of imprisonment is more than 7 years, sir. Lifetime disqualification. Lifetime disqualification. So you are disqualified to act as a director on a permanent basis. You should not continue in the position of directorship of any company, public, private, OPC, nothing. So this is relating to period of imprisonment. So 3 classifications are there. Less than 6 months. What will happen less than 6 months? Is there any disqualification attracts? Less than 6 months, no disqualification. So 6 months to 7 years. 5 years disqualification will be attracted to you before, from the starting of imprisonment data, after releasing data. As and when your sentence is expired, or from release date, from that date, 5 years countdown will begin, and till 5 years you are not allowed to act as director in any company. If your period of imprisonment is 7 years, permanent disqualification. So you are disqualified on a permanent basis. Okay. So next one, you achieved maximum number of directorships. You achieved what? You achieved maximum number of directorships. Sir, achieving maximum number of directorships means, do you know how many positions you can hold? How many directorship positions you can hold on a simultaneous basis? 20. Is there any subclassification in this 20? maximum number of directorships allowed for a specific person is 20. Very good. Out of the 20, maximum directorships of 10 public companies are allowed. That means you can accept 20 assignments, but public company assignments more than 10 you are not allowed to accept. You can accept public company directorships only up to 10. Only up to 10. And remaining other company directorship. Other company directorship. In this 20 calculation, section 8 company directorships, LLP directorships are excluded. In this 20 calculation, in this 20 directorships calculation, what kind of directorships can be excluded, ma? Section 8 company directorship positions will not be counted in this 20. And if you are acting as a director in any LLP, so that kind of positions also, directorships also will be excluded from the countdown of 20. And I think few days back, 1 or 2 days back, I have asked you a question. Is a section 8 company private company or a public company? Tell me the answer. Private company or public company? Private company or public company? Section 8 company is not a private company, neither a public company nor a private company by its nature. It all depends upon how you will incorporate it. That means you can incorporate a section 8 company as a private company or as a public company. Both ways allowed. Both ways allowed. Now listen. Listen. You are acting as a director in 9 public companies. 9 public companies. And one more public company is offering assignment for you. Very good. Congratulations. You can accept. Why? Because so far as concerned, you are acting as a director for 9 public companies only. One more public company is offering assignment for you, and one more public company, which is section 8 company, is also offering you position of directorship for you. Many people are loving you. That is why many directorship offer are automatically coming towards you. 9 public companies already you are acting as a director. One more public company intends to appoint you as a director, and one more public company, which is section 8 company, is planning to appoint you as a director. Now tell me, is both assignments can be accepted, or only one assignment you should accept and another assignment you should reject? How you will accept both assignments? Why? Because section 8 company, even though it is a public company, it should not be counted in this 20 limit. So that is why this public company directorship should be included. Included or excluded? Included or excluded? You should not count section 8 company directorships, whether it is a private company or it is a public company. Don't involve section 8 company directorships into this countdown. It's completely out of the purview of this section. You can accept, no issue. Okay, so that is why you can accept both the assignments. Why? Because even though you accepted the both assignments, the limit is well within the limit specified in the act. Why? Because 9 public companies, you are already acting as a director. One more public company, total sums up to 10. Yes, well within the limit. One more section 8 public company, even though it is a section 8 public company, it is not considered for the calculation of this 20 limit or 10 limit. That is why this person can accept both the assignments. Are we clear? So maximum number of directorships. Tell me how many maximum number of directorships a person can accept? 20. Out of that, sublimit is 10 public companies. 10 public companies. And mind you, This is not a hard and fast rule. Company specifically include some more stringent provisions in their articles and put some sort of restrictions upon acceptance of assignment by their director. Say for example, I started a company. I recruited one of the person as a director for my company. Very good. I am paying 5 lakhs per month as remuneration per month, not per annum. 5 lakhs per month as remuneration to this so-called director. The director is accepting so many assignments. If he accepts multiple assignments, obviously efficiency of the work will be diluted, right? Why? Because he has to manage lot of relationships. So maintaining one relationship is way more easy than maintaining multiple relationship. I think few of you are very very well experienced with this kind of circus or stunts. Okay, so say for example, he is accepting 5 assignments. Okay, very good, no problem. He accepted 6th assignment, 7th assignment, 8th assignment, 9th, 10th. Okay, Companies Act is allowing him to accept multiple assignments. But who is paying remuneration, me or Companies Act? Hey, Abraham Rageswaran. Who is paying remuneration? That is my question. Company belongs to me only. That thing you have to say. So company is paying the that is, I am paying the remuneration, not Companies Act. Companies Act ఏం పోయిందమ్మా 20 కాకపోతే 40 యాక్సెప్ట్ చేయమంటది. బట్ వర్క్ చేయాల్సింది ఎవరు? డైరెక్టర్. రెమ్యునరేషన్. So being the efficiency is reducing, I am in a plan to impose restrictions upon the maximum number of assignments that can be accepted by a director, and I have made a new amendment to my AOA, Articles of Association, and as per that Articles of Association, I am placing some new restriction that my directors, whoever directors working in this company, are not allowed to accept more than 6 assignments. Out of that 6 assignments, 4 must be maximum 4 public companies, 2 remaining private companies. Like that, I am placing some sort of restrictions in my AOA. Am I allowed to do so? Tell me, am I allowed to do so? Yes, I am allowed to do so. Why? Because in order to secure the efficiency of the workers, efficiency of the directors, I am placing these restrictions. So not with any other malified intention. That is why Companies Act is giving free hand to the companies to place this kind of restrictions and all. As far as Companies Act is concerned, Companies Act is saying that a person can accept up to 20 assignments. Out of the 20 assignments, max 10 public company assignments he can accept, and out of these 20 assignments or 10 assignments, whatever there, you should not add section 8 public company assignments, LLP directorship assignments, you should not include. So that is what the general rule is saying. Again, Companies Act is giving a free hand to the companies, saying that if your directors accept multiple assignments, the efficiency or work capability or paying attention of directors will be reduced. Then you may come up with lot more restrictions, and we are not placing any sort of objections to such restrictions. We are giving free hand. You can add more restrictions, but you can't extend it. Say for example, Companies Act is saying 20, sublimit 10. You came up with a new amendment in your Articles of Association and giving free hand to your directors that, my dear director, you can accept up to 25 assignments. Out of the 12 assignments are public, 13 are private. Is it allowed? No. That kind of restrictions are not allowed. You can put even more strict and stringent requirements. That is allowed. So this is regarding max number of directorship, maximum number of directorships. Are we clear? Tell me, maximum number of directorships are how much? 20. out of that sublimit is there, and the sublimit is pertaining to public companies, and public company assignments are maximum 10, not beyond that. And in the 10 limit or 20 limit, you should exclude section 8 company assignments. Even though that section 8 company is a public company, you should not add it. Are we clear? Tell me the first point. Unsound mind. If a director is a unsound mind person, he is perfectly qualified to act as a director. Qualified or disqualified? Disqualified. Second one, insolvency. Either court declared him as insolvent or his application is pending before the authority with respect to adjudication and all. So in any case, he is disqualified to act as a director. Companies Act is specifically mentioning these points. And the third point is, if court or tribunal pass a specific judgment saying that our court imposes restrictions, or court specifically disqualified this person to continue as a director or to appoint as a director in any company, then for the time being the order is in force, he is disqualified to act as a director in any company. Okay. Next, fourth one, imprisonment. Imprisonment, if the imprisonment is very less, up to 6 months only, no specific disqualification will occur. More than 6 months up to 7 years, then 5 years disqualification will be attracted to the person, and the 5 years will be calculated from the date of release or date of expiry of sentence. Third case, imprisonment period is more than 7 years. Lifetime disqualification. That is all about period of imprisonment. And next one, maximum number of directorships 20. Out of that sublimit 10. If company wish to place even more strict restrictions by amending AOA, it is perfectly allowed. In order to secure the efficiency of directors, it can do so. Companies Act is allowing to place such kind of restrictions by the companies. And sixth point, related party transaction. What transactions, ma? Related party transactions. So if you committed any offense with respect to section 188 related party transactions, then you are disqualified to act as a director. I'll tell you. And one more point is also there. So apart from related party transactions, one more point is also there, and the point is, if director failed to pay the call money, I think you very well know about application money, allotment money, first call, second call, final call, or call money. A director subscribed for few shares. Director paid application money and allotment money. Or director paid application money only, allotment money or call money is still due. And even after making so many reminders and all, director failed to pay the call money or allotment money, whatever the money that is pending with the director is unable to pay the money to the company. Then what it indicates? It indicates the seriousness of the director towards the execution of works. You yourself are the director is not so concerned about the execution of the company or growth of the company, then how come he is eligible to drive the company in a profitable way? So that is why Companies Act is specifically disqualifying such kinds of directors. So let's read the material first. So disqualification, these are all the disqualifications which we have studied so far. First of all, 164.1, disqualifications applicable to all companies. Why? Because these disqualifications are personal disqualifications, whereas 164.2 Not to all companies, only to specific companies only. Those companies which made defaults under 164.2. For those companies only 164.2 is attracting. So let's talk about 164.1 first. First of all, a person shall not be eligible to be appointed as director if he is of unsound mind has been so declared by a competent court. Who has to decide you as an unsound minded person? Court has to decide, not your friend or not your parents or not anyone else. Next one. He is an undischarged insolvent. Very good. Or he has applied to be adjudicated as insolvent and his application is pending before the court. In these both cases also that person is disqualified to act as a director. Next. He has been convicted by a court of any offense involving moral turpitude or otherwise, whatever the offense it may be, okay, and sentenced to imprisonment for not less than 6 months, not less than 6 months, that means more than 6 months, then he is disqualified for 5 years from the date of expiry of sentence. And if imprisonment is 7 years or more, disqualification is permanent, that is lifetime disqualification. That is, if imprisonment period is less than 6 months, then no disqualification attracts. That is the point. And an order has been passed by a court or a tribunal disqualifying him. That means specifically a court or a tribunal expressly passed an order saying that so and so person, Mr. X, is not allowed to act as a director. Mr. Y is disqualified. Mr. Z is disqualified. And the order for the time being is in force. Then this point attracts. That means so far as the order is in force, that we should not appoint such kind of persons as directors in any company. Next, he has not paid calls on shares held by him and such calls are unpaid for a period of 6 months from the due date. So company gave lot of alerts or reminders to pay the call money. Even after multiple reminders and all, you are not willing to pay the call money and you didn't pay the money, call money, and more than 6 months already passed, then disqualification attracts. Last point, he has been convicted of offense dealing with related party transactions under section 188 in the last 5 years. That means in last 5 years you committed an offense under section 188 related party transactions, then you are disqualified. So these are the disqualifications of a director on a personal basis. This is 164.1. 164.1. Okay. So next one, 164.2. So is everybody got the clarity relating to 164.1 disqualification? On a simple note, tell few disqualification: unsound mind, insolvent, court or tribunal order, maximum number of assignments, imprisonment, period of imprisonment, 188 related party transactions. Last but not least, director failed to pay the call money to the company and regarding the due more than 6 months has been passed. Then such persons are such a person is disqualified to act as a director. Okay. Keep this point in mind. If you are attracted with 164.1 disqualification, then you should not continue your ongoing assignments and you should not accept any new assignments. That means if any disqualification attracted to you under section 164.1 and currently you are acting as a director for 7 companies, all 7 postings, you are automatically vacated to the office. That is what we call casual vacancy. Yesterday, even before the expiry of the term, director vacated his office by whatsoever reason may be: resignation, death, disqualification. This is only casual vacancy director concept. What is this point? Disqualification means automatically you are treated as you are a vacant director. You will be treated as you simply provided the resignation to the company, you vacated the office. Simple. Next one, 164.1. So this is all about 164.1. Whenever 164.1 disqualification attracted, you have to vacate the office immediately with respect to ongoing assignments, and you are not allowed to accept any new assignments also. Sir, till how many days I should not accept any assignments? Sir, depends upon the disqualification. Say if you are the disqualification is pertaining to your imprisonment, it may be lifetime disqualification or it may be 5 years disqualification, like that. What, ma? Anything to say? Okay, right. So next one, this is all about 164.1. So shall we proceed to 164.2? Disqualification, company level disqualification. So till now we discussed personal level disqualification. Personal level disqualification. Now we are discussing company level disqualification, that is 164.2. 164.2. Sir, what are these disqualifications? If company is irregular, company failed to file financial statements, company failed to file financial statements or annual reports with ROC for a period of consecutive 3 years. Consecutive 3 years, any 3 years, no, consecutive for a continuous period of 3 years, company failed to file the financial statements or annual reports with ROC, then company level disqualification will be attracted to the all the directors who are there in the company. Or this is one way. This is one way. And another way is also there. This is one type of indiscipline. And another type of indiscipline is also there, that is financial indiscipline. Financial indiscipline means not about losses or anything, ma. If company fail to pay dividends, sir, is paying dividend mandatory? No, but after declaration you have to pay. So if you don't declare any dividend, no one will question you, but after declaration you have to pay the dividend. Fail to pay the dividend, you fail to repay the deposits, you fail to repay the debenture holders interest or principal, whatever is there, and more than 1 year has been elapsed from your default date. More than 1 year has been passed from the date of default. That means board of directors are working in efficient way, or they are inefficient? They are inefficient. That is why 164.2 level, company level disqualification will be attracted, and whoever directors are there in the company, all are disqualified. Sir, disqualified means they immediately vacate the office and go to home and take rest. No. Disqualification here means they are not allowed to continue in the position called directors. This is point number 1. Point number 2, they should cooperate to the new management to rectify this mess. Why? Because all these years they used to be very indisciplined, right? So if any new management is elected by the shareholders, this existing, the so-called inefficient people are there, no, they have to guide or they have to give the proper information. They have to cooperate with the new management to clean up this mess. And the third point is, whenever company level disqualification occurs, whenever company level disqualification occurs, he is not allowed to accept any new assignments also. And for reappointment also, he is disqualified. Say for example, X is the director of ABC Limited, and any of the disqualification happened with the company. Any of the disqualification means ABC Limited failed to furnish financial statements for a consecutive period of 3 years, or ABC Limited is financially indisciplined. fail to pay the declared dividend, fail to repay the deposits or debentures or interest, whatever that is there, then all the directors that are existed in the ABC Limited are disqualified, and those directors are not allowed to accept new assignments also, and these directors are not eligible for reappointment in this company. That means ABC Limited is not allowed to appoint the so-called inefficient directors again as directors. Disqualification as per 164(2) occurs. And students will be in a confusion state with respect to ongoing assignments. Say for example, X is a director in 8 companies. How many companies? 8 companies. One of the company is financially indisciplined, or one of the company failed to furnish the financial statements for a consecutive period of 7 years. Due to the default, X got disqualification attracted by section 164 subsection 2. What about remaining 7 positions? What about remaining 7 companies? If they are compliant enough, it means if those 7 companies are following proper rules and regulations, and those companies are financially in a disciplined way, and those companies are filing financial statements and annual returns to ROC properly, then he can continue with the ongoing assignments. That means there is no need to vacate the ongoing assignments. No need to vacate the offices of ongoing assignments. He is not allowed for 2 things. He is not allowed for 2 things. First one, reappointment in the same company. Why? Because you proved to be inefficient. That is why reappointment not allowed. And the second one, you should not accept any new assignments. Sir, until after 5 years we can accept that. If any shameless person proposing undergoing your profile for the position of directorship and all, okay, jogi raskunte boodu ralindani. Next one. So listen carefully. 164(2). 164(2). Very important. And whenever a practical question framed according to 164(2), above 95% of people, students, will commit mistake. Why? Because it seems to be everything is clear when you are listening to the classes. But when you have to analyze, but you have to implement the provision in a real-time scenario or a case-based scenario, you are prone to confusion. So understand the provisions properly. If you got 164(2) disqualification, then you are not allowed for 2 things: reappointment in the same company, any fresh appointment, and any ongoing assignments are happening, and those companies are compliant enough with the rules mentioned in this Companies Act. You no need to vacate the offices of those 7 companies or those existing assignments. You can happily carry on with the ongoing assignments. And one more thing I have to tell: if any new director came into the company, he's a newcomer, just 3 months or 4 months or 3 to 4 months has been passed after the appointment of the director, and meanwhile at least 3 to 4 months time we have to give to the person to understand the scenario, whether in order to form a judgment whether this company is a good company or a bad company and all. Just few months we have to allow, right? That is why Companies Act is allowing 6 months time. Companies Act is allowing 6 months time. Say for example, if any new directors appointed in the so-called disqualified company. Which company? Disqualified company means the company which is failing to furnish the financial statements for a continuous period of 3 years, or the company which is financially indisciplined. So there is an exemption for newcomers. If any new director appointed to the company and less than 6 months has been passed after the appointment, then no disqualification will be attracted to the newcomer according to 164(2). Companies Act on a humanitarian grounds, Manavata Drukpadanto, on a humanitarian grounds, Companies Act is allowing some sort of exemption to the newcomers. Why? Because he's a newcomer, ma. Just 6 months, 5 to 6 months, or 3 to 4 months, or 1 to 2 months has been passed out just after his appointment. That much buffer time we should allow to understand the situations. So that is why if you are a newcomer, newly appointed, and your appointment to the date of disqualification by the company and all, and less than 6 months has been passed just after your appointment, then you no need to vacate the office. You can continue. And according to 164.2, no disqualification will be attracted to you. That is what law is saying. So there is a exemption for newcomers. Newcomers means how many months allowed? 12 months, huh? Just 6 months. Just 6 months. Why? Because the financial indiscipline is existed from more than 1 year, and with respect to filing of financial statements and annual reports, that indiscipline is existing from last 3 years. How come he is responsible? Why? Because he is just a newcomer. For whatever the mistakes done by the previous director, we can't punish the newcomer. That is why Companies Act is specifically exempting these newcomers from this punishment, from this disqualification. That is why 164.2 disqualification is not applicable to these newcomers. Are we clear? We just completed 164.1 and 164.2. 164.1 and 164.2. Let's read 164.2. Disqualification due to default by company. A person cannot be reappointed or appointed as director of any other company if he is or was a director in a company that has not filed financial statements or annual returns for. This word is very important. Default should be pertaining to continuous period of 3 years, not any random 3 years. You will play cricket, huh? 3 miss out rule is there, no? 3 miss out rules, if you miss any 3 balls, continuous 3 balls. If you miss continuous 3 balls, then only you will be treated as out. Likewise, here also same rule. If company failed to furnish financial statements or annual returns for a continuous period of 3 years, then the company is out. Chichi, the 164.2 disqualification will be attracted. Okay, right. Next one, or means either you may satisfy this condition, or second one is what? Company has failed to repay deposits, interest, redeem debentures, or pay declared dividends for more than 1 year. So either you may satisfy first set of condition or second set of condition. If you satisfy any of the condition or both the condition, then immediately 164.2 disqualification will be attracted to you. 164.2 disqualification, and such person is disqualified for how many years, ma? 5 years from the date of default. This provision applies to all companies, not just listed ones. Not just listed ones. So this is 164.2 is saying. So what about 164.1? Personal level disqualification. That means disqualification attracted to you due to your default, due to your commitments, due to your behavior or acts or conduct. 164.2 disqualification is not happening due to your conduct. It is due to company's irresponsible administration conduct. For this kind of irresponsibility, not only single person is responsible, board of directors are collectively responsible. That is why 164.2 disqualification applicable to all the directors that are existed in the company except newcomers. Except newcomers. That is the point. 164.1 clear? Personal level disqualification. 164.2 company level disqualification. 164.3 disqualifications you have additionally included in your AOA. Sir, what kind of matters I can include in my AOA? Whatever matter you may wish to, you can include in your AOA, but make sure that those restrictions are not against the provisions of the Companies Act 2013. So far as your restrictions are not inconvenience or in contravention with the Companies Act 2013, they are allowed. If you are deviating with the spirit of law, then they are not allowed. What ma? No, not included in this position. Why? Because creator's default is a very common thing in any company. So that is a different thing. Creator's default, they can proceed according to IBC, Insolvency Bankruptcy Code. That is a different thing. I will tell you at a later point of time. So as of now, creators are not involved, not included in this definitions purview. Okay, right. So 164.3 what? Additional disqualification by AOA. So very simple. Companies can add additional disqualification for directors in their AOA. They must not override the provisions of the Act. They must not override the provisions of the Act. Act means Motor Vehicle Act. Which Act we are studying? Companies Act. Very good. So what are the consequences of disqualification? If a person becomes disqualified under section 164, maybe 164(1), 2, 3, whatever it may be, he must vacate the office as per section 167(1), except in case of 164(2), that too for private companies. That is a newcomer director is there, no? That is the thing. Next, MCA maintains database of the disqualified directors, and such individuals are barred from holding directorship in other companies as well. Debarred. So it is very simple, man. Nowadays, if you know a DIN number, how many directorships he is holding, whether he is qualified or disqualified, you can easily check in online way. MCA website you can check. This is the total summary table. Disqualification under section 164(1), 164(1), unsound mind, insolvency, criminal conviction, court order, calls unpaid, related party transactions, all these are 164(1). So unsound mind declared by court, insolvency, you made application and your application is still pending or application is accepted by the court. Criminal conviction, when permanent disqualification will be attracted to you. If your imprisonment period is 7 years or more, then permanent disqualified. 6 months to 7 years, 5 years disqualified from the release date. Court order, prohibited by court or tribunal, calls unpaid for greater than 6 months. Related party offences, if you are convicted under section 188, very important, 184, 185, 186, 188, very important sections, I will tell you. Okay, 184, 185, 186, 188. And nowadays 202 and 191, compensation for loss of office. With respect to these concepts also, examiner is trying to test the knowledge of students. I will tell you. Next one, this is all about 164(1). What about 164(2)? Non-filing of returns or financial statements for how many period? For how many years? 3 consecutive financial years. And you may default in repayment of deposits or debentures or interest thereon or declared dividend, and your default is greater than 1 year, then everybody in your company are disqualified. And 164(3), additional disqualification depends upon the conditions you are mentioning or adding in the AOA, Articles of Association. So are we clear? We just completed disqualification, not qualification. Okay, let's read qualifications now. So these are the qualifications of directors under Companies Act 2013. So first of all, you know this point very well. Only individuals are allowed to act as director. No body corporates or no artificial persons. I have already told this point in beginning session, first session itself. One blind person can't show a proper way to the another blind person. As per the same rule, here also one artificial person can't properly administrate another artificial person. That is why only human beings, individuals, are allowed to act as directors. Okay, so as per section 1491, only natural persons can be appointed as directors. Body corporates, firms, associations, or any other legal entities cannot be appointed. And with respect to DIN, there is a big concept. I'll tell you. Not now, don't worry. This one. So this is the entire information pertaining to DIN, all about DIN. Okay, so this is the whole information. This is the summary. So we'll discuss this tomorrow. God bless you. So we'll discuss this. Not tomorrow. Oh, sorry. Monday. Sunday, yeah? Sunday or Monday? Anyway, I'm going to have sessions for tomorrow, if I'm not wrong. Why? Because for your seniors, I have to take. So DIN, I'll tell you day after tomorrow. I think in next session, Monday. So next one, resident director. I think you know this person very well. Resident director, and there is a tricky point in this section. Tell me. Very good. Even a foreign national can also be act as resident, can also be appointed as resident director. That means the provision is making restriction with respect to period of stay and place of stay, not with respect to citizenship. If you stay for 182 days or more in India in the previous financial year, allowed to act as resident director. And I think you know these points also very well. Additional qualifications for independent director. You should not be related to the promoters group or promoters, or you should not be an employee. You must not have any pecuniary relation. You must be a person with integrity and honesty or whatever. So be a person of integrity, not be a promoter or relative, no pecuniary relation, not have been a KMP or employee in the last 3 years. So these are the qualifications for independent director. So no specific qualification has been expressly imposed as per Companies Act in order to occupy a position called director. No educational qualifications also mentioned. Why? Because there is no relation to skill and education. So these are the few qualifications under Companies Act 2013, and part 2 disqualification I think we have already completed. DIN we will complete tomorrow. So say for example, this is all about DIN. So qualifications, qualifications of director, only individual, which is mandatory. DIN mandatory, no specific educational qualification. Additional qualification as may be required in case of, for IDs only additional qualifications will be imposed as per Companies Act 2013. For any other position apart from ID, no specific qualifications has been purported by Companies Act 2013. And if you are a normal director, no specific age limit is there. If you are 18 plus enough, you are allowed. Sir, 18 plus needed. Of course needed. Why? Because if you are a minor, are you allowed to enter into contracts? No. So next one, if you are MD, if you are considering for the place of MD or WTD or manager. Why? Because these guys has to do the executive work. On a day-to-day basis, they have to take a lot of decisions. That is why age-wise restriction is there. Why? Because their workload is comparatively way higher than any other director. So for that person, minimum age is 21, maximum age is 70. If greater than 70, SR needed, special resolution needed. So it is simply enough for the qualifications. When it comes to disqualification, this is all about DIN, I will tell you later. Comes to disqualifications of director under section 164. This is 164.1. unsound mind, undischarged insolvent, applied for insolvency and application is pending, disqualified by court or tribunal, achieved maximum number of directorship. In this directorship, companies can also place additional restrictions on this number if they wishes to do so. I have already told this point. You may follow 20 limit and 10 sub limit, or you may place even more strict restrictions. It is completely allowed. Companies Act is giving you free hand according to this point. And maximum how many directorships ma? 20, including public, private, OPC, dormant, including everything. This 20 excludes Section 8 company directorships, LLP directorship. Sublimit is equal to 10 public companies, and only exemption for this 10 is, you have already told this point in the previous case, no? Why you are hesitating to say? Next one. This imprisonment. Imprisonment less than 6 months. No disqualification. Greater than 6 months up to 7 years. 5 years from the 5 years from the expiry of sentence. Greater than or equal to 7 years. Permanent disqualification. If you are convicted under section 188, disqualified. Not paid calls on shares till 6 months from due date, disqualified. Okay, in the above case, he or she is disqualified from that particular company only, not applicable to other directorships. Not applicable to other directorship. You have to vacate those positions. Next one, disqualification due to default by company. Company fails to file FS means AR annual returns for 3 consecutive financial years. What is this? Or company failed to repay deposits, debenture, interest, dividend, and this default subsists for more than 1 year. Then such directors disqualified for 5 years from the date of default. So no new appointments or reappointment in the default company till 5 years. But he is already acting as director in other companies and they are compliant enough with rules, then he can continue with them. This section applies to, but relaxation and disqualification is allowed to new directors. Means from the date of default, those directors who appointed recently in the back calculation 6 months, from the date of default you go back until 6 months, whoever directors are recently appointed, yes sir, one director appointed, exempt that director from this 164 to disqualification. And this is additional disqualification by AOA 164.3. Company can add the disqualifications through AOA. Okay, so this is the entire handwritten book relating to Mahila Mandali. కాసేపు జుట్టు పీక్ కొట్టుకుంటారండి మీరు. ఏందమ్మా డిబేటా? ఎనీ డౌట్? ఎప్పుడమ్మా? ఇంప్రిజన్మెంటా? Up to 6 months. 6 months also allowed. Not beyond 6 months. That is the spirit of the provision. Okay, 6 months or less. Clear? Okay. So, this is the entire handwritten book relating to directors and KMP chapter. And lot of pages are there. And regarding board meetings and procedures. So, కొంతమంది అనుకుంటున్నారు ముందే ఇదంతా మాకు షేర్ చేస్తే మేము రాసుకునే, కొంతమంది రాసుకుంటున్నారు. ఓకే, దట్ ఈస్ ఎ డిఫరెంట్ థింగ్. బట్ what is advisable? I am having handwritten notes for each and every chapter, but I am not going to share. That is magic. So you have to write on your own, whatever the language. I am going to share. See, within coming 2 months or 2.5 months we are going to complete our syllabus, right? Just after completion of syllabus I will share every handwritten notes of each and every chapter for your revisionary purposes. Meanwhile, what will happen if I share in the earlier note? Obviously, no one will write. Sir, you are giving assurance that you are going to share at the revision times and all. I might share. I may share or I may not share. Depends upon my mood and all. Okay? But listen. There is a concept called BMC, body mind coordination. If you write properly, it will be equivalent to 3 times reading memory. Why? Because if you write, body mind coordination will happen by whatever language or whatever mode. No need to write like an artist. No one is going to check your notes except you. So if it is able to if you are able to understand the language, in whatever language you may write, Telugu, English, Hindi, Tamil, Malayalam, Kannada, whatever language you may write, that is highly suggestible, especially in theory subjects. Why? Because you are prone to sleep also. There are certain concepts, CG, corporate governance. That guy is expert in sleeping. Huh? Okay, we'll pay special attention on that guy. So all these concepts are somewhat okay, somewhat interesting, but we will experience some dry topics later. Corporate governance, sustainability development. So those concepts are very important from examination point of view, but those concepts are not that much exciting as these concepts are. That is why make a habit that you are going to write something in the classes. No one is going to check, but make sure you are holding pen and whatever book, rough book, or your friend's book, whatever book it may be. If no space is there, write on the table or write on the person next to you. Anything is allowed. All I need is you have to write. వాళ్ళు చూడండి మంచిగా వైట్ షర్ట్స్ వేసుకొచ్చారు, వాళ్ళ దాని మీద రాసేసేయండి. ఉన్నారు వైట్ షర్ట్స్ 1 2 3, వెరీ గుడ్. సో దిస్ ఈజ్ ఆల్ అబౌట్ qualifications of directors and disqualifications of directors as per Companies Act 2013. Tomorrow we'll discuss, next session we'll discuss DIN first. After that, appointment, reappointment and all. This is the matter relating to DIN, completely written. And after that, this is appointment, reappointment, rotation of directors and all. Lot of concepts are there. We'll discuss at a later point of time. Okay, that's all about today's session. Thank you.